So, what are we going to be talking about today? Well, we're going to be talking about the similarities and differences between stop and search powers, depending on which piece of legislation is being employed. We've only got an hour, so this isn't an exhaustive look at stop and search powers. But as I say, we'll be looking at comparing and contrasting some of the powers that do exist. We'll be asking the question that Colin's already mentioned. Do police always need reasonable suspicion, or does Colin fitting a profile, will that do? Or do blanket orders give them sufficient power to stop and search? And then we'll turn to look, perhaps most importantly for the lawyers amongst us, about the admissibility of stop and search evidence. How might I get it excluded? And if I can't get it excluded, how else might I deploy the evidence at trial? And I'll give you, I'm sure Colin will have a couple of examples, as will I, of ways in which we've dealt with this at trial. So, continuing on under Section 1, requiring reasonable suspicion, as we said, you may search any person, vehicle, or anything on or in a vehicle for stolen or prohibited articles. And you can search somebody, of course, if they're in a public place. Public place is quite clearly defined as well, isn't it, within the Act, isn't it, Colin?
Yeah.
And so, for example, it includes, I think, premises where somebody might have to pay a fee for entrance, for example.
Yes.
And it might be that the police, you might be standing in someone's garden. And in certain circumstances, that might allow the police to search you. In some circumstances, it might not. For example, if the police have just chased you out of your house and you are in somebody's garden and they don't think it's a garden in property that you own, then they would be entitled to search you in those circumstances. However, if you were merely standing in your own back garden, minding your own business, and they were to come through your back gate and try and search you then that would not constitute a public place. So, as I say, it will depend. You might be in a back garden, and in certain circumstances, that might or might not be a public place.
Yes, the general definition in English law of a public place is any place to which the public would ordinarily have access, whether on payment of a fee or otherwise. But we are talking about places where the general public have access. We're not talking about places to which only a segment of the public have access.
Yes,